In recent years, the court has made decisions that suggest that perhaps it is moving away from a strict understanding of the wall of separation doctrine and is moving more toward some kind of accommodation with religion. First, we'll look at the case of Lemon versus Kurtzman. In this particular case, the court established a three-pronged test, meaning a three-part test, to decide the constitutionality of government law, rule, or action with regard to the Establishment Clause. So when is a government law, rule, or action is constitutional, and when is it prohibited by the Establishment Clause? So to be constitutional, the court said government law, rule, or action must meet all three of the following. First, it has to have a valid secular purpose. Secular means not religious. Second, the primary effect of this law, rule, or action must be neither to advance nor to inhibit religion. And third, this law, rule, or action does not lead to excessive governmental entanglement with religion. So the Lemon test comes from this case, Lemon versus Kurtzman, and has nothing to do with actual lemons. If you're looking at a lemon, that's just my lame attempt at humor. Now, this test has a strong side, and the strong side is its simplicity. It's easy to grasp. The language is simple. What it says, seemingly simple, but the downside of this test is that it is deceptively simple, meaning that when you begin to apply it to specific cases, the complexity of decisions is such that you can never predict for sure which way the court will go in any particular case. So the Lemon test has proven in recent years not to be very effective in terms of predicting which way the court will go. So it is unclear exactly how things will develop, especially since over the last 2 decades or so, we have been in a condition of stalemate, in that we have had 4 conservative justices, 4 liberal justices, and 1 in between. And so this remains the case today. The most recent replacements would be Sonia Sotomayor and Elena Kagan, who replaced David Souter and John Paul Stevens. She had 2 liberals being replaced by 2 liberals. We still have this balance that is even between liberals and conservatives. To give you an example of why Lemon test is not very predictive of actual decisions in specific cases, Van Orden versus Perry and McCreary versus ACLU were 2 cases decided by the Supreme Court on exactly the same day in 2005. In the first case, Thomas Van Orden sued Texas in federal district court, arguing that a 10 Commandments monument on the grounds of the state school capitol building represented an unconstitutional government endorsement of religion. So Van Orden argued that this violates the First Amendment's Establishment Clause, and that the state should remove the 10 Commandments. So the question became, does a 10 Commandment monument on the grounds of a state capitol building violate the First Amendment's Establishment Clause? And the Supreme Court gave an answer in a 5-4 decision that the answer is no. And how come does it not violate the Establishment Clause? The court found the reason why is because the 10 Commandments monument wasn't there alone. It was there in the company of other displays, other plaques, other monuments, those that commemorated, the Alamo, other parts of Texas history. So the court said this display is not really about trying to establish or promote religion. It actually has a valid secular purpose, and that purpose is to honor the heritage of Texas as such. And the 10 Commandments is a part of its heritage, is part of its culture. So the purpose here was not religious. McCreary versus ACLU. McCreary is a county in the state of Kentucky. The ACLU sued 3 Kentucky counties in federal district court for displaying framed copies of the 10 Commandments in courthouses and also in public schools. And the ACLU argued that the displays violated the First Amendment's Establishment Clause, which prohibits the government from passing laws respecting an establishment of religion. The District Court and the Sixth Circuit Court of Appeals rules the displays violated the Establishment Clause, and the Supreme Court agreed. It said the Establishment Clause was in fact violated. Well, why? How is this case different from Van Orden versus Perry? In a 5-4 decision, the Supreme Court said the reason why this display of 10 Commandments in the courthouses and public schools violates the Establishment Clause is because the displays of 10 Commandments were there all by themselves. They were not in a company of other displays. Therefore, what is the purpose of having these displays of 10 Commandments? Well, the purpose must be to advance religion. If you didn't want to push religion, you would either not put up the 10 Commandments, or you would have 10 Commandments and a bunch of other stuff there, like a bunch of historical or cultural stuff. Since this wasn't happening, the Supreme Court actually ruled against McCreary County and in favor of ACLU. So 2 cases decided on the same day, slightly different circumstances. The court is splitting hairs based on the context of displays. If they're all there by themselves, you can't do it. So this is where we are. We are left with the state in which it is up to the courts to decide and to split hairs, historical, semantic, logistical, which 10 Commandments are displayed with which other monuments, and does it all make historical and cultural sense, or is it just an attempt to push religion? This is where we are currently in American constitutional history with regard to the Establishment Clause.